Okay.
All right. So with that, good afternoon, everyone. Thank you so much for joining us for Constitution 101 this evening. My name is Emily Voss. I am the Director of Education at the Robert H. Smith Center for the Constitution at James Madison's Montpelier. And we are delighted this evening to have with us Professor Dick Howard. And before I formally introduce him, I'll just say a couple items about interacting with our speaker for the course of the evening. So we are excited to welcome your questions several times throughout tonight's presentation. The best way for you to do that would be to use the chat feature at the bottom of your Zoom screen. And just to make sure that's working, if those of you online right now wouldn't mind dropping into the chat, letting us know where you're from so that we make sure that everybody's working and you can communicate with us accordingly. So you all are welcome to post chat questions at any time as the evening proceeds, and we'll make sure that we can address the questions as Professor Howard has the time to pause during his presentation. All right. So we have Debbie from Richmond. Hello, Debbie. All right. We have Moline, Illinois, Standardsville, Virginia, John Douglas Hall, the famous to us anyway, John Douglas Hall, Gaithersburg, Maryland, Charlottesville. We have Westmoreland County, Virginia, West Granby, Connecticut, Elk Grove, California. Woohoo! This is great. Well, thank you all so much. So we can confirm at this point anyway that the chat is in fact working. All right, so let me go ahead then and formally introduce our speaker. So widely acknowledged as an expert in the fields of constitutional law, comparative constitutionalism, and the Supreme Court, A.E. Dick Howard. Dick Howard is the Warner Booker Distinguished Professor of International Law at the University of Virginia. Professor Howard is a graduate of the University of Richmond and received his law degree from the University of Virginia. He was a Rhodes Scholar at the University of Oxford, and after graduating from law school, he was a clerk to Justice Hugo Black of the Supreme Court of the United States. His bio is quite lengthy, but I will mention that he's the author of a number of books, articles, and monographs, which include The Road from Runnymede, Magna Carta, and Constitutionalism in America, and commentaries on the Constitution of Virginia, which won a Phi Beta Kappa Prize. And more recent works include Democracy's Dawn and Constitution Making in Eastern Europe. And he's here with us this evening on the occasion of the 50th anniversary of the Constitution of Virginia. So those of you who have joined us many times before, you'll know that we usually dig into the United States Constitution, but this is a pretty rare and pretty amazing opportunity to dig into the state constitution of Virginia. And there's no one better to speak about this topic than Professor Howard. So Professor Howard, please take it away.
Thank you, Emily. Some of you may know that I'm an old friend of Montpelier. I served on the board there at one point, indeed on the property council back in the early days when the National Trust was running Montpelier. So I obviously in my field, teaching and writing about constitutional law, James Madison is bound to be on my horizon much of the time. That so much of it started with him. So it's an appropriate place to talk about any kind of constitutions. And as Emily pointed out, I want to talk today about state constitutions. Now that's may sound a bit esoteric, but it in fact is not. It's very basic to the whole system of American constitutionalism. Now, when I was a law student at the University of Virginia some years ago, I don't remember any of my professors talking about a state constitution. Now, maybe I skipped class or was dozing that day. I mean, I might simply have been inattentive. I confess to all of that, but I don't remember that they talked about the state constitution. Well, I was asked to be executive director of the Commission on Constitutional Revision. I'll talk about that in a few minutes, but that was my real serious introduction to the world of state constitutions. So let me, before I talk specifically about Virginia's constitutional history, let me say a word about state constitutions as such. And I want to start with a proposition that may seem idiosyncratic. And that is that the federal Constitution, the United States Constitution, is by design an incomplete document. By design an incomplete document. Now, whoa, that sounds kind of strange. What do I mean by that? What I mean is that when the framers met at Philadelphia in the summer of 1787, state constitutions already existed. Beginning in 1776, we'll talk about the first Virginia Constitution in a moment, but as of the 1770s, each of the original states had a state constitution, and they were operating, they were the documents under which state governments operated. They had bills of rights, they had frames of government, they were complete operating documents. So when the framers met at Philadelphia to write the federal Constitution, they were aware of and assumed the existence of state constitutions. They don't actually say anything about them. If you read the text of the federal Constitution, the word state appears probably 50 times. It's obviously they knew a lot about the states, but they didn't ever define a state. They didn't tell you what a state was because everybody knew. They all lived in a state. They knew what they were. The closest the federal Constitution comes to defining a state or its system of government is the provision that says Congress shall guarantee each state a republican form of government. But in the 1840s, there was a dispute in Rhode Island between two factions, each claiming to be the legitimate government of Rhode Island. And that dispute went to the US Supreme Court, and the court refused to decide the case. They said, deciding what is a republican form of government is, in the technical sense of the word, a political question, which is to say non-justiciable, not for the courts. So the Supreme Court was not willing to tell us what a republican form of government is. And to this day, we don't have any Supreme Court gloss on that question. So we have to find out what in the world is a state constitution. Well, let me give you just a quick sketch of why state constitutions matter. And then let's talk specifically about the Virginia Constitution. State constitutions, as I say, they preceded the federal Constitution. And that period of the 1770s and 1780s was a period of experimentation. It was the dawn of the age of writing modern constitutions. The United States Constitution is the oldest national constitution. France had Europe's first constitution in 1791. So in the 1770s, when people were writing state constitutions, they were not quite sure what it was they were writing. They had some ideas. They were trying out this approach and that. Some states had unicameral legislatures. Some had bicameralism. Most states had bills of rights. Not all of them did. But one dominant theme appears in those early constitutions, and that is legislative supremacy. Judges were thought of in connection with royal judges in the colonial period. Governors in the colonial period were royal appointees. The only branch of government that was thought to be close to the people was the lower house of the colonial legislatures in Virginia, the House of Burgesses. So when the Americans were writing their first state constitutions, not unnaturally, they looked to the legislature as the branch closest to the people and therefore the one that ought to have the most power. Indeed, governors were not elected by the people at the outset. New York in 1777 wrote the first constitution that had a governor elected by the people. Separation of powers was a theory, but not practice. It was not until 1780 that Massachusetts wrote a constitution that had really authentic separation of powers. So there was this period of what I call experimentation, so that when the framers gathered at Philadelphia in 1787, they had a lot of plans and models and other experiments to look at, most of which they found unsatisfying and they rejected when they wrote the federal Constitution. Well, what about state constitutions today? I mean, I'll be very summary. We can talk about this more in the Q&A session if you'd like, but if I can generalize about state constitutions, the first place, they are longer and more detailed, far more detailed than the federal Constitution. They have subjects which don't appear at all in the federal Constitution. For example, the word education never appears in the federal document, but every state constitution has an article specifically about the world of education. State constitutions are periodically revised, frequently amended. They're very easy to amend. As you know, the federal Constitution is very difficult to amend. Ask any proponent of ERA and what a long fight that was. Federal Constitution only has a handful of amendments, the Bill of Rights and a few others. State constitutions get revised all the time and often rewritten. I mean, Virginia's had 6 or 7 constitutions, depending on how you count them. That's very unlike the federal scene. The courts are different. Federal judges have life tenure, life and good behavior, whereas in the states, a number of states, judges are elected by the people. They have to run for office and they have to campaign for re-election. Some states have the initiative. You can actually amend constitutions by bypassing the legislature and putting in amendments. Some states have recall of judges, and that's been used. California and Iowa, for example, the people there have removed judges because they didn't like the opinions they were handing down. Well, that's so different, as I say, from the federal system. So I think one of the interesting things about state constitutions is that they are really a roadmap to the great political and social and economic struggles of American history. The great crises often are reflected in the rewriting of state constitutions. So I think it's worth thinking about the Virginia Constitution and state constitutions generally as something which is really a textbook. It's a seminar, if you like, in civic education, a chance to think about the fundamentals of government, the principles of constitutionalism, and how people make them work or not work, how they could be improved, and the like. So I'd like to convince you that if you've never read your state constitution, I understand we have folks from California, for example, out there. That's a case book in state constitutionalism, the recall of judges and issues and the like. Wherever you live, go take a look at your state constitution. I think you'll be quite stunned at what you'll find in there. You'll find it very educational. Well, I could talk more about that, but we want to talk specifically about Virginia's Constitution. We're now celebrating the 50th anniversary of the 1971 Constitution. And that's a story I want to tell a little bit later on in this particular session this afternoon. So let's go back to the beginning. Let's start in 1776. That's where it all began. There was a convention that had met in Williamsburg in 1776. They were in effect the governing body of Virginia. The royal governor had dissolved the colonial legislature, the House of Burgesses, and told them to go home. Well, they went across the street, Duke of Gloucester Street, and met probably, I guess, in Raleigh Tavern, probably had a drink or two, and then set to work. So in May of 1776, on the same day, May 15, that the convention instructed Virginia's delegates in Philadelphia to introduce the Resolution for Independence, a momentous event, of course, that triggered the process that led to July of 1776 and the Declaration of Independence. On the same day in May that the Virginians initiated that process, they also set to work on a Declaration of Rights and a frame of government for Virginia. Now, I emphasize there were 2 documents that they drafted. Together today, they make up the Virginia Constitution. But in the founding period, the social contract theory was in the air. John Locke's notion, very influential in America, that the first thing you do is you set down your rights. You declare rights as preceding government, that your rights don't depend on government, they are inherent rights. And therefore you set them out in a declaration, and then you move to the business of writing a frame of government. So that's what they did in Williamsburg in 76. Now, they had a number of interesting plans before them. John Adams up in Massachusetts was asked for his advice. He sent down a plan. Carter Braxton from King and Queen County had a plan which was reminiscent of the English Constitution, in particular the English Bill of Rights of 1689. There were other, Thomas Jefferson, interestingly enough, was in Philadelphia. He was a member of the Continental Congress, but he wrote up a plan, sent it down. It got there fairly late, so not much of that actually got adopted. The principal work, as some of you may know, was done by George Mason. George Mason of Fairfax County was, well, they didn't have an organized bar in those days. He was not a practicing lawyer, but he knew a lot of law. He had access to a large library with a good deal of material. He was well read in British constitutionalism and in world history generally. So he was the one who did most of the drafting of the Declaration of Rights in particular, and the Virginia Constitution, the frame of government as well. And this makes good reading, whether you live in Virginia or not. Take a look at the Virginia Declaration of Rights of 1776. It's easy to find because it has carried over into Article 1 of today's Virginia Constitution. It's almost word for word the way that George Mason wrote it. If I were to make up a short list of the 10 most influential constitutional documents in Anglo-American or Atlantic history, maybe in Western history, the Virginia Declaration of Rights would definitely be on that list. It was a model for the other states' bills of rights. It influenced the Federal Bill of Rights. It even influenced the French Declaration of Rights of Man and the Citizen. So, I mean, this is really a world-class document of great importance. And as you read through it, as I say, I recommend it as homework after this session today. You'll notice that the first 2 or 3 sections are straight out of John Locke. They are social compact theory of why government is formed. It's for the common benefit, that if it doesn't work, people can reorganize it to work best for them. It's a far cry from what you would have found in English constitutional documents of that time. Then as you read on through the rest of the Declaration of Rights, then you run into a number of provisions, many of which are drawn directly from English constitutional documents like Magna Carta, the Petition of Right, the English Bill of Rights, and the like. So it's a compendium of what Americans as English colonists understood to be their inherent rights, guaranteed by the early charters, reinforced by their sense of social compact and natural rights. So it's a jurisprudential document of the first order. It's absolutely fascinating. So that's the one that's endured. Now, by contrast, the frame of government was anchored in its time. They were documents that, I mean, it was a document which has not survived. The rest of the frame of government for Virginia today hardly resembles that which they set out in 1776. And there were problems with it that, as forward-looking as the Declaration of Rights was, the frame of government part was clearly anchored in the economic and social and political interest of the elite, the ruling class of that day and time. And Jefferson was just apoplectic over the first Virginia Constitution. I've always had a theory that part of his peak was the fact that he wasn't there, that it was hard for Thomas Jefferson to imagine you could write a constitution without him being at the table. So whatever the psychological urge, for the next 50 years, he criticized the original Virginia Constitution, and he had several criticisms of it. First, he criticized suffrage. He said, in effect, I'm going to get into suffrage a little bit more as we move along, but essentially, it didn't specify that only property owners could vote, but it was framed in a way that it assumed the status quo. So if you didn't have property, you didn't vote. And Jefferson, that means people who are fighting and putting their lives on the line in defense of this emerging country can't vote. And that's clearly wrong. He said that they should have the franchise as well. Secondly, Jefferson complained about malapportionment. We talked today about partisan gerrymandering, which I hope we'll talk about a bit later on. But he said, unfortunately, that frame of government preserved the power structure, which gave the small, old tidewater counties down near Chesapeake Bay the power over the growing Piedmont and Valley of Virginia. They were the sort of, they were the population growth centers of Virginia, and they were underrepresented in the apportionment. So he said that means Warwick County, which has a handful of people, has as much power as, say, Loudoun County, which had something like 17 times the population at that time. He said that's clearly wrong. He criticized the lack of separation of powers. I mentioned that these early constitutions placed supremacy in the legislative branch. The Virginia Constitution mentioned separation of powers, but Jefferson said it was not a reality, that the legislature had all the power, and he said 176 despots would be as bad as one. So he didn't like that provision. Finally, one of his basic complaints about that first Virginia Constitution was, he said it wasn't legitimate. He said the same body of men who make ordinary laws for Virginia purported to write a constitution. And that doesn't work, because that means if they can write it, they can unwrite it, they could change it as if it were an ordinary law. It needed to be a body of men elected for the purpose of writing a constitution. And that did not happen in Williamsburg. I might say I'm a native Virginian. I don't go around giving a whole lot of credit to Massachusetts, but I have to give it here that in 1780, Massachusetts called a convention elected for the purpose of writing a constitution. And that document in turn was presented to the people of Massachusetts for their vote. And so it was Massachusetts that perfected the idea of the Constitutional Convention in a way that the people in Virginia had not. Now, I might say on the question of legitimacy, it's interesting. Many of you listening in today will know about John Marshall's opinion in Marbury versus Madison, his famous 1803 decision that pronounced the doctrine of judicial review, the power of the Supreme Court to strike down a legislative act as being unconstitutional. It's interesting and not widely known that there were Virginia judges in the 1790s who were already saying the same thing, that in dictum, there were opinions of judges on the Virginia Supreme Court that said if an act of legislature contravened the Constitution, it would be their reluctant duty to say that it was not valid, it was not lawful. And that's precisely what John Marshall later said in Marbury versus Madison. So that's where it all starts. I'll make one comment and then we might pause and see if there are questions coming in before we move on from there. But as a bridge from that early 1776 period to further Virginia constitutional development, let me once again mention Thomas Jefferson. Now, forgive me for talking a lot about Thomas Jefferson, but I teach at the university founded by Thomas Jefferson, and it's written into my contract as a law professor that I can't give any talk in any public forum without at least one reference to Thomas Jefferson. So I'm obliged by contract to talk, so you'll forgive me, I'm sure. But there's an interesting letter that Jefferson wrote in 1816 to a friend of his, Samuel Kercheval. And in it, Jefferson talked about the need for generational change in constitutions. He said, we respect our ancestors, we salute what they did, but he often said in his correspondence with other friends, Jefferson was fond of the phrase, the earth belongs always to the living generation. We honor the past, but we can't live under the dead hand of the past. So he said, each generation should revisit the Constitution. He looked at mortality tables of Europe in that period. And they showed that of all the people who were alive at any particular point in time, in 19 years, half of those people would be dead. So he said that's a generation. So he recommended, rounded off to 20 years if you like, but that's basically every 20 years, each generation would get to rewrite the Constitution. So a question I want to pose after our brief Q&A is whether, whether Virginia has in fact lived up to Jefferson's edict or not. So Emily, let's pause there. I think my audience, my friends out there are being very patient. So let's see what they have to say.
Absolutely. Okay, so we first have a question from John Douglas Hall. When new states were added to the Union, the territories had to prepare a constitution that would be accepted by Congress. If that constitution has been changed by a new state, wouldn't such a change have to be approved by the Congress again?
I haven't got the foggiest. That's a fast thing. John Douglas Hall, thank you for leading off with a question that the professor doesn't have an answer to. Thank you for that, for showing that my knowledge is not limitless. As you can imagine, Congress has not been asked to approve those constitutions. I have a feeling here's my guess. This is only my guess of the answer to that question. The Constitution has a provision of equality for states. So once states are in the Union, they're all on the same basis. So the newly admitted states have every jurisprudential right in sovereignty, 10th Amendment rights, all the rest of it that the original 13 states had. I assume that would be read to say that once Congress has approved the original Constitution, then the state is turned loose, it's free, as any other state would be, to rewrite its Constitution. They have been continuously rewritten, revised, amended, and all the rest. I'm sure the fact is Congress doesn't have the states on an apron string, and I think that's the reason, but that's my best guess. Thank you for that question.
Yeah, that was a great question to
Great question.
Well, I have a few clarifying questions. So, we talked about the state constitutions, largely kind of coming up in the years right before and during the Revolution. So prior to the state constitutions, the British Constitution is unwritten. So where did the states sort of collectively get the idea that they should have written constitutions?
I think that's a wonderful question, because when you look at the history of the period, the debates and the like, it was clearly assumed that if you were going to be an independent country, you had to have constitutions. I mean, that's the lesson of the Williamsburg Convention, that on the same day, if we're going to be a free country, we have to have a state constitution. So they had already made up their mind in answering the question that you've just raised here. Now, where did they get that idea? I think partly from the charters which they had. They relied heavily. For example, the Virginia Charter of 1606 was a corporate charter, the Virginia Company of London, but it had an interesting provision that said that those who emigrated to the New World would be guaranteed the liberties, franchises, and immunities that they would have enjoyed in the mother country. That was taken by the Americans to be, in effect, a constitutional guarantee. So I think the written charters were prelude to written constitutions. Secondly, John Locke and social compact. The notion that when you enter from a state of nature into a state of society, that's a compact, that sort of invites you to have something in writing to sort of codify whatever that might be. Thirdly, I think covenant theology. It's interesting, that is a very important root of American constitutionalism. The notion that there's a covenant between people and God leads you nicely to the thought that, well, let's have a covenant. The Mayflower Compact would be a good example of a covenant written up to govern people in that New England colony. So I think all those things were coming together, and you had the precedent in England in the 17th century when Parliament was struggling with the Stuart Kings. You had in 1628 the Petition of Right, 1689 the English Bill of Rights. These were liberty documents. They are cornerstones to this day of the English or British Constitution, which, as you rightly say, was not codified then, was not codified today. I think these things simply came together in a way that the Americans were devising ways of guaranteeing rights that Europeans could not claim. In France, for example, they wrote their first constitution in 1791, but the National Assembly was the voice of the people, and to contravene the wish of the assembly was treason, the reign of terror and all that. So American constitutionalism puts the world in effect on a distinctive path, to the point which today, what we have, like 200 countries in the world, and virtually every country has a written constitution. Some of them, of course, are worthless pieces of paper. We know that in China, for example, or the Soviet Union, or Cuba, but they're obliged to have that written constitution. So it's somehow the American founders fastened on the idea we have to put it in writing.
So my other clarifying question, I have no problem, by the way, I mean, you can shout out to Thomas Jefferson all you want, no problem. But our young James Madison, I believe that this is his first foray into politics, is participating in this convention in Williamsburg to write this first state constitution.
Right.
And then, please correct me if we're wrong about that one, but that his particular interest in that document, as a very young man, is language that protects the freedom of religion within the state. Can you say more about that?
That's absolutely right. He was 25 years old, one of the youngest, maybe wasn't the youngest, but I don't know what you were doing at 25. Well, I was not writing constitutions at 25, I can tell you that. So he was a member, and George Mason's draft for the Declaration of Rights guaranteed toleration in matters of religion. Now, by European standards, that was pretty advanced. There wasn't much toleration in religious matters in Europe at that time, but that again came out of John Locke's letter on toleration. Well, Madison understood, I think quite rightly, that wasn't strong enough. So he moved that the language of toleration be dropped and the language of free exercise of religion be inserted, and the convention agreed to that. Madison's original formulation would have also been read to disestablish what had been the Anglican Church, later the Episcopal Church, as the established church in Virginia. That went too far for the convention. The members were not willing to go that far, so they had to drop that. I'll put Jefferson in the picture once again. Thank you for allowing me to do that, because 10 years later, 1786, Jefferson's bill for religious liberty was adopted by the General Assembly, and that was the one that achieved disestablishment. And it's interesting, there is a case where Virginia's constitutional history was a prologue to the federal Constitution. 1786, you have free exercise and disestablishment, both law in Virginia, and the next year, the framers go to work on the federal Constitution, which of course was amended. The First Amendment guarantees both free exercise and anti-establishment. So in many ways, what happened in Virginia was the legislative history for what then later happened at the federal level. And you can thank James Madison for having put that in motion. Give it a shout out.
Shameless plug for Montpelier. All right, well, so we have no further questions for chat or Q&A, so please carry on.
Okay, let's pick it up from there. You remember before we had the Q&A that I had mentioned Jefferson's notion that each generation should rewrite the Constitution. Well, that was a long time coming in Virginia. The first Constitution, 1776, a lot of defects, a lot of problems. If you lived west of the fall lines, if you lived in Piedmont, Virginia, or the Valley of Virginia, or the transmontane regions of what today is West Virginia, you didn't like the arrangement under the original frame of government because you were underrepresented. And in the East, the planters did not want to be taxed to support the internal improvements like canals and railroads and the things that in the West were needed. East, they had the rivers. They didn't need other modes of transportation. But if you lived west of the fault lines, you needed those things. So, and the planters didn't want to pay for them. So they liked things the way they were. They liked the status quo. So almost every year there would be petitions lodged in the General Assembly saying it's time to call a constitutional convention. It didn't happen until 1829 and 30. And finally, all those years after the original document, a constitutional convention was assembled. An amazing group of people. John Marshall was there, even though he was Chief Justice of the United States. He was in the Virginia Convention. Future presidents were there, governors, senators, everybody who mattered was there. Those debates have been published. If you're a real Constitution junkie, it's worth dipping into those debates. They are, Merrill Peterson once called them the last gasp of constitutional disputation of the founding period. I mean, they are amazing debates. Well, the debates are pretty impressive, but that convention didn't in fact accomplish very much. It modestly changed, it somewhat enlarged the franchise, it modestly changed the apportionment of seats, but it was not really a reform body. It was not until 1850-51 another convention was called, and then Virginia is not always the first to reform. We know that. In 1851, finally, the Constitution provided that the people would elect the governor. So for 75 years, the governor was not elected by the people. Finally, he was. And then finally, the Constitution had something close to white, male, universal suffrage. Obviously white, obviously male. Women were not voting until the 20th century. So, but at least a reform was in the air. Something was accomplished there. Then, of course, things come unglued with the Civil War and Reconstruction. And that period is one that I think invites close attention. And let me kind of set the stage for that, why that's important, Reconstruction and post-Reconstruction, by quoting the language, going back to George Mason's Declaration of Rights, that in that declaration, the language is still there. It's very inclusive language when it sets out the purposes of government, that it's instituted for the common benefit of the security of the community. It doesn't limit that. It's a very inclusive way of putting it. But when they turn to the question of suffrage, then it's qualified. And the Declaration of Rights says that to be allowed to vote, you have to show some common interest, some permanent attachment to the community. Well, at that time, that meant property. But the language was sort of sufficiently open-ended that it did permit of enlarging the franchise beyond simply property owners. So one of the central battlegrounds over the centuries of Virginia constitutionalism has been precisely who is it that's entitled to the franchise. So as I pointed out, by 1851, you have something like universal white manhood suffrage. And then comes the Civil War and Reconstruction. And in 1867-68 in Richmond, a convention is met, totally different from the ones before the Civil War. Most of the traditional conservative leadership of Virginia was not there, former Confederates and their office holders. This was the first time that African Americans were in a constitutional convention. There were roughly 100 delegates, and about 25 of them were Black. Some were former freedmen, most were former slaves. So that was a pretty remarkable gathering. Now, you may know that the Confederate States after Appomattox had to, in effect, petition to be readmitted to the Union. They had to do two things. They had to ratify the 14th Amendment, and they had to write a progressive state constitution, in particular one that would guarantee the suffrage for Black Americans. Well, the 1870 Constitution, the one that came out of that convention in Richmond, did just that. It had basically, again, male franchise, but one without regard to race. And so African Americans were widely represented in the Virginia electorate in the years after the adoption of that Reconstruction era Constitution. Well, times then changed. If you know something about the post-Reconstruction period, you may know that in 1876, there was a disputed election. And in settling that election, one part of the package deal was that federal troops would be withdrawn from the South. 1877, the last federal troops left Louisiana. And then the process of retrenchment began. The conservative forces were gathering themselves. They couldn't reinstitute slavery. The 13th Amendment took care of that, but they were going to turn the clock as far back as they could and basically tie blacks in a position of inferiority to the white political forces in the state. So first they had Jim Crow laws. This happened throughout the South, not just in Virginia. In Virginia, perhaps more than any other Southern states, African Americans were often the balance of power, especially in some local elections in Southside Virginia, where blacks were a majority of the population. There were political factions. There was a so-called readjuster party who wanted to readjust Virginia's pre-Civil War debt. They appealed for black votes as well as white votes, and they actually had governors and legislators and others elected during that period. That didn't last because the conservatives, they called them Bourbon Democrats after the Bourbon kings in France, they wanted to re-establish the stated pre-Civil War status quo as far as they could, along with the same sort of sentiment in the other former Confederate states. So starting about 1890, the former Confederate states began to rewrite their state constitutions, starting with Mississippi in 1890. Other states followed suit. They used a number of devices, the poll tax, exemptions for Confederate veterans or their sons. They automatically got the vote. They had so-called understanding requirements that you had to read a section of the state constitution and interpret that. There are any number of ways that were put in place in Mississippi and other states to prevent blacks from exercising political power. Virginia joined the queue in 1901, 1902. And again, if you want remarkable reading, rather different from those earlier conventions, the debates of 1901, 1902 are in print. They were transcribed, and you will not be surprised at what you find there, but I think you'll be shocked all the same. I mean, today, in a number of states, alas, there are efforts to retrench and take voting rights away from people. I lament what's going on in some states like Texas and Florida and others. I have to be very frank about that. I think that's undermining the democratic institutions in those states. And the reason it's being given typically is protecting the integrity of the ballot, which of course is a perfectly legitimate objective. Today, if you wanted to sort of trim back on the vote, you would dress it up in language of anti-corruption and integrity and all that. They didn't do that in 1901, 1902. They were upfront. I mean, they were going to set out to discriminate, and they said so. They didn't make any bones about it. First thing they wanted to do was to get rid of the Reconstruction era, the 1870 Constitution. They said it was imposed on Virginia at the force of federal bayonets, as if the military who were in Virginia at that time had imposed that Constitution by force. They said that was an affront to Virginians. We're going to toss it out. So, and the flag that the delegates planted in 1901, 1902 was unmistakably white supremacy. That's what it was about. It was the natural right of the Anglo-Saxon race to exercise superiority over inferior people. And by the way, and then you may know the history of this period, this was not simply a Southern phenomenon. Of course, it was anti-blacks in the case of Southern state constitutions, but in the North, similar sorts of things were taking place. First, the Irish immigrants, and then from Italy, and then from Eastern Europe, and Jewish immigrants and the others, as they were coming to America, they sort of native white Protestant population saw this as a threat, and they set out to invent ways to discourage voting by those new Americans as well. So, and I think you have to keep that in mind, because you may wonder if these southern states are disenfranchising blacks, what's happening in the North? Why didn't they do something about it? Why didn't Republicans in the North complain and come down on the South? Well, they didn't. It was the Gilded Age. They were more concerned about trade, but admitting new Western states and commerce, and the Gilded Age was underway, and they frankly weren't too worried about what was happening to blacks in the South. So the Southern states had essentially carte blanche. And so the debates, if you read those debates, are really, as I say, really quite remarkable. They said that they were setting out to eliminate the Negro. That's what they called, well, they even had other coarser phrases, but to eliminate blacks as an element in Virginia politics at the state level and the local level. Indeed, as I read some of those debates, there were delegates who weren't too keen on having lesser classes of whites in the franchise, that they thought they were rabble, the mob. They thought respectable people like them, in other words, should be the ones to run the state. So what place did they have for blacks if they weren't going to be permitted to be part of the franchise? Well, they said, yes, they have their place. It's on the land, in the cotton fields and in the tobacco barns, and as agricultural laborers, that's fine, as long as they mind their place. There are even moments, some of the delegates seem to betray a nostalgia for slavery, suggesting that, everybody was better off when blacks were on the land and the master was imposing his will, and that was keeping the peace in a brutal and direct kind of way. But maybe that wasn't too bad after all. History and theology were brought into play. I mean, delegates said that, you can look at thousands of years of history, and what have blacks ever accomplished? That they haven't given us art or culture or architecture or great inventions, that pretty much it's a blank slate. Theology was called into play. I mean, delegates will say it's God's plan. God has ordained that the Anglo-Saxons are the superior race, and others will just have to accept their lesser place. I think the delegates realized there had to be some kind of rudimentary education for Black Virginians, but they didn't want to spend any money on it. It would be wasted money. One delegate pointed out, said, what you're going to do? You're going to have schools for blacks in Virginia. They'll learn to read. They're not going to read the Bible or good books like that. They'll read trash. There were things like Uncle Tom's Cabin and get some uppity ideas. So that would be a waste. And certainly you're not going to educate blacks to become doctors or lawyers. They can't go into the learned professions. They'll be competing with whites, and that simply can't happen. So, I mean, they go on and on like this. Say it makes mind-numbing reading to read what these folks had to say in Virginia. And I grant that seems like a long time ago, but it's not much more than a century. It's not ancient history. We're not talking about the 17th century or something. So they're very upfront. In fact, in one point in the debates, Carter Glass, who was on the floor, was asked by another delegate, won't these provisions you're putting into place discriminate? And he said, discriminate? What do you think we're here for? We're here to discriminate just as far as the federal Constitution will allow us. What he had in mind was the U.S. Supreme Court. Because, I mean, you must be wondering, given this, if Professor Howard's account is accurate, if this is a fair statement of those debates, surely the U.S. Supreme Court's not going to stand idly by and let all this happen. Well, it did. There was a case in 1898 from Mississippi challenging that post-Reconstruction Constitution, and the Supreme Court rebuffed the challenge. They said the Constitution is equal on its face, the language was equal, and they weren't going to look at how it might be administered in some discriminatory fashion. Well, with a case like that on the books, the Virginia delegates knew they had a green light. They could do pretty much what they pleased. So what they pleased was the poll tax. And the poll tax was $1.50 a year, which doesn't sound like a lot of money, but in 1902, for a working man, that was a lot of money, probably a day's wages. And it was cumulative. If you didn't pay it last year, you had to pay it for both years. Well, poll tax, Confederate veterans and their sons were automatically on the rolls. You had property, you were enfranchised also automatically. But if you didn't meet the other qualifications, then you had to go to, you went to register, you went to the registrar. He could open up the Virginia Constitution at random to any provision and ask you to interpret it. Well, I have to tell you, there's some sections of the Virginia Constitution I'm not sure I can interpret, and I'm supposed to know something about it. But you go to the registrar after 1902, and you're the wrong color. There's no way in the world your explanation is going to satisfy the registrar. You're going to be turned away. Well, you know that. So you're not even going to go to undertake a futile gesture. You know, you're not going to give up a day's pay to go and just be turned away. So the result was grimly efficient. The convention wanted blacks off the rolls, and they accomplished just that. In 1867, blacks represented about half the registered voters in Virginia, the majority in some parts of Virginia. In 1904, with the new Constitution in place, that figure plunged to less than 5%. It was just a handful, and also a number of poor whites were disenfranchised. So if you wonder what was the roots of the so-called bird machine in the early 19th century, look, you can trace it back to the 1902 Constitution as an important part of it. So they say they were grimly efficient. Now, what about the adoption of that Constitution? The delegates to the convention in 1901 they'd been elected, morally pledged to put the proposed document to referendum. Well, given the story I've been telling you, I think they sat around and said, you know, we're going to disenfranchise hordes of people. Maybe they'll vote no on this maybe they don't want this Constitution. So the convention decided to simply promulgate the Constitution. They didn't put it to referendum. They just said to the people of Virginia, you now have a new Constitution. Well, some people said, wait a minute, that's not legitimate. So there was a case in the Virginia Supreme Court where a man convicted under a statute passed after the adoption of the 1902 Constitution said that statute's not valid because the Constitution was not legitimately adopted. The Supreme Court of Virginia sort of uncomfortably shuffled from one foot to another and said, well, the governor and the judges and the legislators have all taken the oath of office under this new Constitution. It must be valid. And so using that particular curious kind of logic, they rebuffed this particular plaintiff's complaint. So Constitution was settled into place, and that was the order of things for the next half a century in Virginia, right up until the 1950s or 60s. And why don't we pause again for a moment, Emily? I've gotten us up to the threshold of the present Constitution, but let's see if people have any questions at this point.
Folks, yeah, you're welcome to use chat or Q&A. So I'll ask a couple of questions here too. So notwithstanding perhaps the 1904 Constitution, but certainly the 1850 Constitution. So is there popular energy in the House of Delegates that says Virginia needs a new constitution? We should vote. And yes, we are voting to create a new constitution. We have to pull together a convention for that purpose, et cetera, et cetera. So, you know, kind of what are the nuts and bolts that go into actually saying, let's just scrap the one we have and start over?
Well, there are two ways to write if you want to write a new constitution in Virginia. This is fairly similar to other states, and that is you can call a convention. The legislature could provide for the calling of a convention and the election of delegates, and that's what they did in 1901. And they had the election of delegates, as I've described. The other way is actually the device that we used in writing the 1971 Constitution. And that is to simply have the proposed new Constitution in technical terms as an amendment to the old Constitution, which sounds kind of technical, but it works that way. Then you don't have to have a separate convention. You have the legislative. First, you have a drafting commission. I'll talk about that in a moment. We had a commission on constitutional revision. And they in turn make their recommendations to the General Assembly. General Assembly then decides what they want to do. They receive those recommendations. They approve a draft, approve a proposed constitution. Then, because it's in technical, it's one big amendment. It's the whole Constitution, but it's still an amendment in jurisprudential terms. So that requires that it be approved by 2 sessions of the General Assembly, separated by an election of the House of Delegates. So once it's approved the first time around, it has to then be reapproved. Then it goes to the people in referendum. And that's the process we undertook in writing the present Constitution of Virginia.
Okay. And so my other question then is, kind of what's the hinge point of, the scales to say, are there more changes there then it's worth just doing an amendment for, or a series of amendments, or does it make more sense to scrap the whole thing and start over? Like where does that decision process happen?
I think that's a political question. I mean, there's no obvious answer to it. It depends on the momentum of the time, what people think of the great issues. The fact is, now we should talk in a minute about the present Constitution and should there be changes to it. But for the last 50 years, amendments have been fairly common. I mean, it's easy to, as these things go, compared to the federal Constitution, it's not that difficult to amend this or any other state constitution. So most anytime you go into the polling place in Virginia, you get the ballot and it'll have constitutional questions on it. Mm-hmm. Chances are you didn't even know they were being talked about. A lot of them are purely technical, very small scale, but once in a while they will rise to the level of something that people care about. But so far, at least, and this, I'm getting ahead of myself on this, I think the 1971 Constitution has actually stood the test of time. It's basically a serviceable document. Any changes that ought to be made can be made by individual amendments. I don't sense any particular sentiment around Virginia that we ought to rewrite it. Maybe that day will come, but I think it hasn't come yet.
Okay, thank you. And John Douglas Hall with another great question. Could it not be said that the U.S. Congress was complicit in the Virginia Convention of 1902 in allowing it to proceed?
Well, I think the political forces in America, Congress, the White House, the U.S. Supreme Court, the Republican Party, all these people were complicit. I mean, I just think it's quite stunning when you think about the accomplishments of Reconstruction, the advances that were made, the 13th, 14th, and 15th Amendments, the enfranchisement of former slaves, the creation of public education systems. I didn't mention that the 1870 Constitution created Virginia's first public education system, its first statewide system, underfunded and limping along, but at least it was there. It was a beginning. So all these things had happened, and yet it wasn't that many years after the Civil War that the backsliding began. That not only did the South begin to fall into the hands of conservative forces that wanted to turn the clock back, but the North kind of just let things go. They moved on. They were too busy making money and admitting new states and indeed doing things like becoming a colonial power. I mean, 1898, Spanish-American War, just before the Virginia Convention, we clean Spain's clock and we acquire the Philippines and Puerto Rico, and we were becoming, like European powers, a colonial power. And if you read debates in Congress, and I'm glad the question asked about Congress, if you read debates in Congress on what should we do about the Philippines, there was a faction like William Jennings Bryan was not in Congress, but people who followed him said, look, America doesn't do colonies. That's not the American tradition. European, so we ought to let the Filipinos go on the path to independence. But what carried the day was the imperialistic arguments. Members of Congress, quite interesting speeches of the time, in which they said, well, you know, we need coaling stations, there are military reasons, whether we want to secure trade with the Philippines, there are economic reasons. And in particular, we have a sort of moral imperative that we should bring the blessings of American civilization to the less fortunate people in the Philippines. This is kind of a missionary instinct that the American flag should be planted and carry with it American values. That was what carried the day in the years after the Spanish-American War. And that is so parallel to the way people were thinking in the Virginia and other post-Reconstruction constitutional conventions, that the Anglo-Saxons were meant to carry the benefits of civilization to lesser peoples. And that meant they were the ruling class in southern states. They were the natural colonizers at the federal level. So the kind of talk, the ideas that were lofted in Congress at that period would in their way be so similar to the debates that you read in Virginia. And then of course the Supreme Court was complicit. I talked about the Mississippi case. I mean, this is the age of Plessy versus Ferguson. In the 1890s, just again a few years before the Virginia Convention, the Supreme Court had given its imprimatur to separate but equal in transportation. And that, of course, blessed implicitly segregated schools. So the Virginia Convention explicitly in 1902 said that there shall be that education of blacks and whites shall be in separate schools. It's all of a piece during that period. I think it's easy to write off what happened in the South as being a Southern issue. It is a national phenomenon in which those who were the levers of power throughout the country really were of like mind. It's also the era of the so-called lost cause, reconciliation, the notion that North and South should come together. You had fraternal meetings of former Union and Confederate soldiers. They would meet at battlefields and sort of shake hands and do that kind of thing. And I think in general, the North said, you know, we shouldn't be vindictive. We don't want to punish the white South. We understand the problems they face. They were really quite sympathetic to it. In the early 20th century, you read about the rise of the Ku Klux Klan. And it's striking that the state that had the most Klan members in the 1920s was not a Southern state, it was Indiana. So again, I just want to emphasize the point. One of the things I hope folks will take away from this discussion is that as much as we disapprove of and deplore what happened in Virginia in 1902, a lot of other folks were in one way or another complicit in it.
I'll ask you maybe a quick question then, and we can then move on. But you brought up the interesting point of the era of colonialism. So this is also, you know, the era in which the United States acquires territories for the first time, and many of them we still have. So what is the setup in a U.S. territory? Are there constitutions for American Samoa? And if so, is that a constitution that was provided to them in an effort to bring democracy to these new territories? Or is that something that the US is encouraging the residents to do for themselves under their watchful guidance?
There are gaps in my knowledge, and one is that I don't purport to be an expert on the Constitution of American Samoa. I have not read the document. You'll forgive me for being lazy enough not to have gotten around to that. But in general, territories, they do have constitutions. I mean, they're not states, but they, as you say, they're territories, but they have constitutions. And certainly in terms of the forms of government, they would tend to be modeled on the American system. I mentioned the Philippines. It's interesting there that I should give the Americans of that period some credit. They were good intentioned, and they really wanted to plant American education, American courts, American law, and the like. It was obviously somewhat smug in a way that if this was meant to be something that Filipinos would never have thought of doing themselves. But the idea was gradual move towards what civilized system, shall we say, and independence. So courts were created, jurisprudence was implanted, schools were opened. And so it gradually representative institutions, the colonial legislature in the Philippines. First, they had the lower house and then both houses elected by the franchise holders in the Philippines. So they were moving in a direction under American rule that wouldn't have a counterpart in territories of European powers like France or Portugal or others. And so by the 1930s, a convention was called that wrote a Filipino Constitution, which in many ways is modeled on the American Constitution, same president, Congress, Supreme Court. It's a bit more of a blend of American ideas plus some Spanish and French ideas, and indeed some indigenous ideas from Filipino history itself. And finally, of course, World War II intervened, but in 1946, the Philippines did become independent. And sadly, their history has been very checkered after that time. But so as I say, I think it's not totally a bleak picture that Americans went with sort of good intentions, somewhat stunted by our standards today, but compared to the Europeans, they were, I think, more benign.
All right, thank you. Okay, well, I think we can move on to the last section then.
Okay, let's get on to the present time. There are those of us, I include myself among it, who remember the bird machine. I was born and raised in Richmond. I remember the lost cause. I remember all this sort of, the sort of moonlight and magnolias picture of Virginia history that we were taught in schools at that time. On the political level, the bird machine was in place. I mentioned the fact that the restricted franchise had a lot to do with its staying power. It ran the state through courthouse rings, in the various courthouses of Virginia. And that was the status quo until Brown versus Board of Education in 1954. That gave rise to one of the saddest chapters in Virginia history, which is the era of massive resistance. Virginia was one of the leaders in opposing the implementation of Brown versus Board. And that was a period where, frankly, not much was happening. It takes you into the 1960s. And the 1960s has to be remembered as one of the most turbulent decades in modern American history. It was a decade of assassinations. John Kennedy, Robert F. Kennedy, Martin Luther King were assassinated. The 1968 in particular was a really rough year because that was the year of King's and Robert Kennedy's assassinations. There were riots and arson and looting, and a number of major cities and sections of cities were on fire and the like. It was really quite an awful period. Vietnam protests were beginning to take place, and that peaked in the early 70s. On the federal legal and constitutional level, here's where we set the stage for the rewriting of Virginia's Constitution. Because on the federal level, first you had Supreme Court decisions laying down the requirement of one person, one vote. So state and federal legislatures, district lines had to be completely redrawn, including, of course, Virginia. Supreme Court struck down the poll tax in a case coming out of Virginia. Congress enacted the Voting Rights Act of 1965, which included Virginia and a number of other states, so that every change you made in voting laws had to be approved, pre-cleared by the district court in DC or by the Justice Department. That was a phenomenal changes taking place at that level. So in a sense, it seems improbable that in 1968, the annus horribilis, if you like, that in that year, we would start rewriting Virginia's Constitution. But when you think of all these changes taking place, it almost had to happen. And among the sort of ironies of the period is it was initiated by Mills Godwin. Governor Mills Godwin, as a state senator, had signed on to massive resistance. He'd been a supporter of the Ancien regime. And here he was proposing a rewriting. Now, I think, and he didn't put any limit on what the Commission on Constitutional Revision could do. I mean, he gave them a free rein to decide what ought to happen. Now, I have to give Mills Godwin a lot of credit for whatever you may think of his earlier career, for understanding the need for constitutional change and allowing it to proceed unimpeded, and indeed signing off on it when it was finally accomplished. But he appointed a remarkable group of commissioners, one of the most remarkable commissions that has been called into existence in modern Virginia. It included people like Lewis Powell, later sat on the U.S. Supreme Court, Hardy Dillard, who later sat on the World Court at The Hague, Colgate Darden, former UVA president, former governor of Virginia, Oliver Hill, the preeminent civil rights attorney of that era. He was the Thurgood Marshall of Virginia in the 1960s. It was just an amazing group of people. I think the best talent you could have called together at that time in Virginia. So they started their work. Then they needed an executive director. That's where I came in the picture. They needed somebody to be their draftsman, their architect, to sort of help put it all together. You want to build a house, you hire somebody to help. You tell him what kind of a house you want, and then he draws up some plans and helps you achieve it. And I had just joined the law faculty at UVA, and I, as I said earlier, I didn't know much about state constitutions, but being a confident young professor, I said, "Hey, you want to write a constitution? No problem. I can do that." I don't know, what was I thinking, that it was like writing a will or a deed? You go to a form book and just copy it out. I don't, but I took on the job. I expect they didn't know how ill-informed I was. A good thing. And then we had staff assistants. We broke the commission down into 5 subcommittees, each with substantive areas. Each subcommittee had a counsel, a lawyer helping them out, some research assistants and the like. It all took place in a very short period of time. The commission came into being in the spring of 1968 and reported to the Governor of General Assembly on January the 1st, 1969, with complete 542-page report, section by section commentary, a complete exposition of what was being proposed and why. The sort of premises of the convention, of the commission. And I think the central idea may have been to, well, 2 things. First, to put the legacy of 1902 behind us, to close that door, to really move into the modern age. And then the other, to create a accountable, responsible state government, and to let Virginians be in the hands to control their own destiny, and not just leave it up to federal law to constantly tell us what we would be doing. So the report to the General Assembly was, of course, only the first step. The General Assembly then had to approve it. Well, I was asked to go to Richmond and be counsel to the legislature, and again, I didn't know what to expect of the legislature. I didn't know much about their processes, and I feared for the worst, but I thought they did a very responsible job. They rose to the occasion. They had a sense, I wish we had it today, of common ground, bipartisanship, really coming together and putting politics aside and doing the right thing. And so they accepted most of the commission proposals. They adjusted a few of them, probably made the package a little bit better in the process. Then finally, there had to be a referendum. By that time, Linwood Holton was governor. He was the first Republican governor since Reconstruction. And he asked me if I would direct the referendum campaign. Well, again, I mean, I was a law professor. I didn't know anything about politics, but I agreed. I wanted to see it through. So I took the job, took leave from the law school, went around the state making talks to any group that would listen, Black churches, union halls, Republican women's clubs, just anybody from one end of the state, from Big Stone Gap in the far southwest to Nancock on Eastern Shore, and everything in between. We had a full-scale campaign, bumper stickers and lapel buttons and TV advertising and billboards and speakers bureaus. So if you were the Rotary Club and wanted a speaker on the Constitution, we could furnish one. Our concern was misinformation, or lack of it, that people just wouldn't know what was in this Constitution and would be tempted to vote no. So we undertook a privately funded campaign. There was no state money involved at all, not a penny. We raised, laughably by modern standards, $100,000 for the whole campaign. Today, that would be a drop in the bucket, but it was enough. We had a lot of volunteer help and a lot of lot of support from across the political spectrum, Democrats, Republicans, and independents. It was my first encounter with conspiracy theories. My goodness, when I was out giving talks, some of the comments I had in discussions with in public meetings surfaced. And one, for example, some of the opponents of the new Constitution said it could not have been written in Virginia. That good Virginians would not have written this document. It had to have been written, I don't know, Beijing or Moscow or worse yet, maybe New York or Chicago. But it was an alien importation. And I had to say, well, look at the people who wrote it. Lewis Powell, Colgate Dart, and all those folks. And 140 members of the Virginia General Assembly approved it. Strange, very far-fetched conspiracy. So luckily, we didn't have to deal with social media. It would have been nailing that snake would have been more difficult, I think, than it was back then. So we had a massive, ambitious public education campaign, which in the final analysis paid off. We got 72% of the vote, which in politics, if you were running for office and got 72%, you would consider yourself fortunate indeed. We lost a few counties on the North Carolina line, Charlotte, Mecklenburg, Brunswick, Prince Edward, a few counties where down there the charge was being made that the proposed Constitution would bring about school busing, which of course was a fiction. But still, you had to respond to that and prove it wrong. So it got adopted. And it became effective 50 years ago this year on July the 1st, 1971. So what did it accomplish? I mean, I should say in general, in the general sense, we reorganized it, made it more pared down. It's about half the length of the old Constitution. The 1902 Constitution, like so many documents of that period, had all the details in there, all the stuff that ought to be in the statute books. So we got all those things out. They belong in the code. We reorganized it. It's more readable. It's more accessible. A layperson, I think, can read through it and get the gist of most of what it's about. In substantive terms, I think the principal accomplishment was in the area of education. That first, to shut the door on massive resistance, the General Assembly is under a constitutional mandate to have a statewide system of public education for every child of school age in Virginia. There's then a mandate on counties and cities to put up their share of the money as required by the General Assembly. And I read it as meaning that the Attorney General could bring mandamus against a locality that did not comply. So in short, no more Prince Edward counties, no more closed schools. In prospective terms, then the commissioners devised the idea of standards of quality. That's a new constitutional phrase, with primacy being in the Board of Education, the final word being in the General Assembly. So there was an effort to push Virginia in the direction of quality education. Some other things, the first anti-discrimination clause that has ever been in a Virginia Constitution is now in this one. Education is now in the Bill of Rights, right alongside free exercise of religion and the like. There's a new environmental quality clause that makes protection of the environment a fundamental value. So it's a vastly improved product, certainly compared to 1902. And it has, I anticipated this comment, I think it stood the test of time pretty well. Now, would I make changes in it? Yes. I mean, there are things that, for example, things we thought we had done in the 1971 Constitution, it turns out that the courts have simply read the document differently. I mean, I can say what I like about what the framers intended, but the courts get the final word, except of course the people in turn can change that. But short of constitutional revision, the courts decide what the Constitution means. To give you a concrete example, we had in the Article 2 in the franchise article, we said that legislative districts have to be compact and contiguous. Now, that's not self-defining, but it's a mandate. It tells the General Assembly how to draw lines. You can't have weird-looking districts that are all over the map that look like a Rorschach test. Well, sadly, the General Assembly, the Supreme Court has basically been unduly deferential to the legislature. The U.S. Supreme Court, many of you will know, recently said that partisan gerrymandering is a political question in the technical sense of being non-justiciable. So you can't take these questions to federal court and get any relief. You look to your state constitution. Well, we have this language in the Virginia Constitution, but the Supreme Court of Virginia frankly doesn't like these cases, is reluctant to second guess the legislature on redistricting. So they have tended to say, well, as long as there's some rational basis for what the legislature does, we'll approve it. To give one case that came up in the 1990s, involved a challenge that districts were not contiguous. There was one district where part of the district was in Portsmouth and the rest of the district was in Hampton. If you know that area there on the opposite sides of Hampton Roads, that's a big body of water. And the Supreme Court of Virginia said, well, the two cities are joined by a body of water and it's therefore contiguous. I mean, give me a break. I mean, that is, if you believe that, you believe anything. So, but they upheld it. That just said, my personal guess is they just don't like these cases. They're not going to be in the uncomfortable position of having to second guess the legislature. Another example is restoring the voting rights of felons. The Constitution makes it clear that once you're a felon, you lose your right to vote for life unless and until the governor restores your the franchise. I won't go into, it's fairly technical, but it's clear to me that the governor can exercise his power wholesale as well as retail. He can confer the right to vote on classes of people, the clemency power of which the restoring of civil rights is part, from George Washington's time onward has been exercised on behalf of classes of people. The whiskey rebels in the 1790s, former Confederates after the Civil War, Vietnam protesters in the time of Jimmy Carter, and so forth. Unfortunately, you may remember Governor McAuliffe tried to restore the voting rights of over 200,000 felons at one fell swoop in one class. He was challenged in court, and the Supreme Court of Virginia, a divided decision, but the Supreme Court of Virginia, the majority held that the governor did not have the power to proceed with a class. He had to restore voting rights one person at a time. I think that opinion is simply wrong. I mean, it happened with all respect to the Supreme Court. I think I read the language differently. Well, but that's, let's say that's the governing principle. So now, as you know, there are proposals to loosen up our restriction. I think the mistake the commission made back in 1971 was simply not to, they should have loosened up the requirement in the first place. If I were in charge of this, I would simply say that once you've served your time, you've been in prison, you're back in society, the right to vote ought to be restored automatically without more. I think that brings people back into the mainstream. They're more likely to be responsible citizens. Now that's a policy judgment. But as I say, that's another adjustment I would make in the 1971 Constitution. People who are tuned in may, in fact, maybe out of pause at that point. There may be other proposals people would like to air or changes they think we ought to make or anything they'd like. So Emily, let's turn it back to you.
Actually, I'm glad you mentioned policy because we have a great question. And I was thinking similar to Lee, who asks, should provisions such as tax exemption for disabled veterans be in the Constitution?
That's
for the non-Virginians, we have seen on our ballots, yay or nay on certain constitutional amendments that some of them seem suspiciously like maybe they should be legislation. So what are your thoughts?
They look like special pleading too, that a particular group is singled out. It tends to be people for whom there's some plausible claim, widows of veterans, that sort of, the orphans, and so how can you vote against that? These things tend to pass. When they're on the ballot, they tend to be adopted. I think I'm of a mixed mind about them. I don't like to see the Constitution cluttered up with things that do look like they're statutory. At the same time, there's a powerful principle that taxation should be on the basis of equality. It shouldn't be too easy for the legislature to carve out special exemptions for particular groups of people. Back in 100 or so years ago, the legislature was in the pocket of railroads and other special interests, and they had a field day, sort of taking care of their own kind. So I think there's a general principle that is in play that may or may not justify these amendments, but may at least go some distance in explaining them. So let's say I confess of a mixed mind about what we ought to be doing with those amendments. But I will say, and this is maybe a related point, I worry when people add social issues to the Constitution. I remember when the Constitution was amended to define marriage as between being a man and a woman. I opposed that at the time. I thought it didn't belong in the Constitution. Of course, it's a moot point now because the Supreme Court in the Obergefell decision a few years ago held that there's a federal constitutional right of marriage at stake that permits and sustains same-sex marriage. So that nullifies the Virginia provision. But at the time it was proposed, I thought that ought to be left to the political process and not to the Virginia Constitution. An amusing example, maybe not so amusing, depending on your point of view, the Constitution was amended a few years back to protect the right to hunt and fish. And I'm not aware that the right to hunt and fish was ever in any danger in Virginia, of all places. But when that came up in the legislature, how in the world, if you're a member of the legislature, are you going to say no to protecting the right to hunt and fish? So that big, and of course, people voted for it. It's now in the Constitution. I think we could do better than having those questions in the Constitution. But that's a policy judgment. If you feel strongly that the right to hunt and fish is a fundamental right, then you want it in the Constitution.
That does make sense. Okay, so we have a question from the Davisons. Would you consider stomping the social media snake, a Virginia or U.S. constitutional opportunity?
Constitutional opportunity?
Opportunity.
Meaning what?
I wonder if the question has to do with, as we were just discussing, is there an opportunity to add some language to a constitution that would, I don't know, protect or disallow things like, I don't know, false information? I'm not sure. But I think you had mentioned the idea of stomping the social media snake and your discussion about the passage of the 71 Constitution, when that would have made things considerably more difficult. I'm not really sure how you overcome it today.
Well, this is not the question, but it does imply, given that I did make that comment about social media, which, and I understand the value of social media, free forum for the generous flow of all kinds of ideas, whether you like them or not. That's the First Amendment, after all, stakes its premise on that kind of flow of ideas. But it means that all kinds of crazy ideas get going. And I mean, to take a concrete example, the notion that so many people believe that forgive me if this sounds partisan, the crazy idea that the 2020 election was stolen, the notion that President Biden is not a legitimate president, I think is simply out of balance. And social media obviously has stoked that. I've advised constitution makers in a number of other countries, especially after the collapse of communism, on constitution making. And I've said, one of the absolute bedrocks of constitutional democracy is that if you lose the election, you step aside, let the other side govern, and you fight the next election. I'd have a harder time using the US as a model in that respect right now. So I say I accept social media. It's a fact, isn't it? It's there. It is, obviously people are going to use it, but the notion that it might be the occasion for amending the Constitution is troubling. And I might say that maybe this is a way of addressing this question, that when we worked on the present Virginia Constitution, one of the questions I thought part of my job was laying issues before the commissioners. Here are the things you might think about, and you decide. You're the policymakers, I'm not. But one of those questions was initiative and referendum. A number of states, California and a number of others, allow citizens to bypass the legislature by proposing constitutional amendments directly. And it goes on about now in the age of the progressive era 100 years ago, that made a lot of sense because legislatures were corrupt. They were in the hands of special interests. And to get the people's business done, you had to go directly to the ballot with constitutional amendments. But my friends in California may have some views on this, but I know out there, every time you turn around, there are an arm's length of constitutional amendments on the ballot. And unfortunately, they don't all fit together. You'll have famous proposition that limited the increase in property taxes very severely. A quite separate amendment another year mandated state expenditures on K through 12 education. So on the one hand, you have this mandate for spending money. On the other hand, tying the hands of those who are supposed to, that doesn't fit. The legislature has to put all that together, but the Constitution won't let them do it. That's no way to run a state, in my personal judgment. So I said to the commissioners, I said, you guys are the policymakers, but if you want my opinion, we would do well not to add the initiative and referendum to Virginia's Constitution. I was not at all surprised that they were that. They didn't need me to persuade them. They did not add that. We don't have the initiative and referendum in Virginia. If we did, that's where I think social media would kick in. I can imagine, some idea just going like a prairie fire through the popular imagination. It then gets on the ballot. It sounds good, or people are mad at the government for whatever reason, and they vote for it. And then it goes in the Constitution. Once there, it's very hard. It's rare that we unamend something, that we take out an amendment. So if that's, I don't know if that's at all responsive to the question, but
I think I think I get the sense that that's where that question was going.
Okay.
Thank you. And it actually cues up I think this will be our last question, because I know we're just a couple minutes over time.
Okay.
Okay, so our last question, I recently moved to Charlottesville for many years, living in Montgomery, Alabama, where vigorous efforts to amend that state constitution utterly failed. The 1901 document was approved fraudulently just 5 years before your mentor, Judge Black, graduated from law school. Alabama's 1901 Constitution has been amended over 900 times and now approaches 1,000 pages in length. Virginia's 1902 Constitution contained much the same language of Alabama's 1901 Constitution, yet as you've outlined, you've corrected many of the worst ills in 1971. What public attitudes allowed Virginia to move forward but have not allowed Alabama to do similarly?
I was law clerk to Justice Hugo Black for 2 years in the 1960s during the age of the war in court. And you can bet we sat around. I would be out at his house in Alexandria on weekends, and we would be working on opinions. And of course, he would tell war stories about his days in Alabama politics. He had been a very successful trial lawyer, probably the most successful trial lawyer in Alabama back in that age, suing the Alabama Power Company, that sort of thing. He ran for the Senate, and you can imagine running for the Senate in Alabama in the 1920s, what a tough haul that was. And he was a gifted orator, and he'd fit nicely. He went to the Senate in Roosevelt's era. He was a supporter of the New Deal. He was one of the architects of the Fair Labor Standards Act, for example. So I imbibed a fair amount of the sense of Alabama politics. After the 1971 Constitution was adopted in Virginia, I had the occasion to go to Alabama and meet with some judges and lawyers who wanted to revise and replace the 1901 Constitution. So I took a look at it. It is now, but I understand in Alabama, if you want to amend a city charter, you have to amend the state constitution. So it's, as you say, it's like 1,000 pages. It's now the longest state constitution in America. It may be the world's longest constitution. Brazil is close behind it, but I mean, it's way up there. So I talked with these folks, and these were sort of the more elite, I'm going to say, judges and lawyers and the like. And the task turned out to be impossible because in Alabama, as in some other states I visited, Oklahoma is another example, you propose to amend the state constitution, and out in the more rural areas in the state, they take up arms saying, you know what they're up to, those fast talking, slick haired lawyers in Birmingham, what they're up to, they're going to raise our taxes. And that's the third rail of state constitutional revision. If they think the constitutional revision is going to be raise taxes, that is a death knell. So the project simply did not prosper. They've had to undertake some piecemeal revisions, which has been helpful. The challenge of revising any state constitution today is much more difficult than it was when we did the job in Virginia. That was an age, and I hate to call it a golden age because that sounds very sentimental, but it was an era, at least in Virginia, where there was a sense of common ground and the common good. And the commissioners, they were bipartisan, biracial, so they represented a spectrum of Virginia, but they were thinking people, and in the legislature, the same ethos prevailed, the sense of what is it that's good for Virginia, not what's good for my political party or my particular constituents. There were exceptions, of course, but by and large, that was the general feeling. And that was conveyed in the referendum campaign, that somehow Virginians were persuaded that the people who had drafted and adopted, proposed this Constitution were acting on the behalf of the people. As I campaigned, I was looking for a campaign theme. And I finally decided that what I ought to be saying as a label for this project was bring government closer to the people. And then I gave examples of how I thought that would be accomplished under the new Constitution. It was because it was cleaner and sparser and more responsive and enabled the people to get government to do what the people wanted. It wouldn't stand in the way the old Constitution had done. It enlarged the franchise and on and on. I think that would be the nearest you could come in Alabama or Oklahoma or any other state to achieving a new Constitution. But the process back in the 60s and 70s, which resulted in some revisions and some failures, has really ground to a halt. In today's world, with social media and partisan politics and the nationalization of the kinds of complaints that you hear in national politics filter down to the state level all over the country, it would make it I don't think we could do today in Virginia what we did 50 years ago. First place, it just might not happen at all. But if you did try to do it, every crazy special interest on both sides of the spectrum, to left and to right, whatever their interest was, you name the issue, guns, abortion, same-sex marriage, on and on, whatever the issue is, on whichever side of it, if that group didn't get their way in the Constitution, they would be against the whole project. I just think it would collapse of its own weight. And if it did finally produce a Constitution, it probably would be a really bad Constitution. So I don't want to sound like somebody defending the ancien regime, that let's bring back the Bourbon Kings or something like that. But I think we were lucky to do it when we did. I bless the people. I say I love Alabama. I've had so many good friends. Some of my best friends, not only Hugo Black, but people I've been associated with in other legal questions with have been friends from Alabama. I've gone down there to give lectures, and I say it's a wonderful place, but it's hobbled, as other states are, by a constitution which was of another day and time, which is simply not ours.
Well, thank you so much, Dr. Howard. This has been such a really fascinating conversation. And I, like to reiterate to all the listeners, our marching orders are to go read your state constitution, whatever state you're visiting us from. Because let's be honest, a lot of us move around, and maybe you've moved to a state and you've not actually looked at the new state constitution where you're living. So absolutely well worth it. And, Professor Howard, it's a rare privilege to be able to hear from someone who has actually written a constitution. So thank you so much for sharing with us today. We've really appreciated it. And so for all of our participants today, you'll get a recording of today's session. So you can, rewatch, you can share it with friends, totally fine. And we hope to also see you next month. Our session will be I believe the 15th of August, Kurt Lash from the University of Richmond will be with us to talk about the Reconstruction Amendments. He has a volume of documents pertaining to the passage of all three 13th, 14th, and 15th Amendments coming out. So we are looking forward to seeing you all then. Thank you all so much for joining us today, and have a great rest of your July. Bye, everyone.
Thank you. Bye, everybody. Thank you so much.